Okay, so we'll make a start now then. Good morning, everybody. My name's Andy Ledger. I'm the I'm the business development consultant for Data Privacy Advisory Service. I'm joined here today with Paul Byrne, who's going to talk about his product, Cookiescan. Just before we get started, just going to run through a few things. First of all, if you've got any questions during the session, please use the chat function and we'll try and address them during the session. If we don't, we'll follow up afterwards. I'd really encourage you to ask us questions, to ask Paul questions. Not too difficult, he asked before the start of the session. But yeah, if you can just keep those, don't hold on to the questions, just ask them as they come into your head, and then we'll try and respond to them as best we can. We are recording this webinar, so if you miss something, you can watch it at your leisure later on. By staying in the webinar, you're actually consenting to the recording. The webinar lasts up to 60 minutes. We'll make the post-webinar materials available and additional resources afterwards. And also, there's a survey at the end of the webinar where we really would appreciate your feedback in terms of how you found it and any further information, any subjects for future webinars and so on, really. So I've introduced myself. I'm just going to get Paul to introduce himself and then we'll embark on that.
Good morning. You can see my name, you can see what I do and who I am. I own a company based in Jersey. We're a data protection compliance business, but also Context Solutions is the digital side of our business, where we've developed a couple of RegTech products, one being Cookiescan, which we will talk about towards the end of this webinar. Just for about a background about myself, I started this business in 2017 after a 24-year career in the state of Jersey Police. Bit of a change, but the last 4 years in the police, I was heavily involved in process improvement, Lean Six Sigma and the like. So changing paper processes, which there was a lot of, to digital processes. So I got a very slight introduction to data protection. Started the business predominantly for process improvement, but because it was 2017, I got a government contract to do a gap analysis for GDPR. So I went out and done a couple of courses to find out what GDPR was, and it's rolled on from there. My own development in knowledge, apart from a lot of practical application of the legislations, is IAP-E, Certified Privacy Manager. I'm a fellow of IAP, and I have a Master of Law degree in Information Rights, Laws and Practices. So I've built up my own academic knowledge, but also practical knowledge. And we're here today to talk about cookies. So there we go. That's me in a nutshell.
Okay, that's great. Okay, without further ado, then on with the show, and just over to you to take us through the slides.
Fine. Thanks, Andy. As Andy said, I'll just reiterate questions as we go along. We'll do a Q&A at the end if you wish, or we have time. But let's have a conversation around this topic rather than me just blurting on the basics of what's required. What we're going to cover is we're going to cover the digital landscape of cookies. Some of you might want to know about pixels or tags. We can include that type of tracking technology. We cover the legal requirements that organizations must adhere to under PECR and ePrivacy directives. It's not a law course. I'm not going to be doing article so-and-so describes that you have to do this. It's a conversational piece, and don't take this as legal advice. Practical strategies to ensure compliance. I use the word compliance, so I quite often put near compliance when I say this, because you'll never be 100% compliant. In the world of regulation and legislation around data or cookies, 100% compliance is a myth. So I'll do near compliance. Key regulatory guidance from the ICO and the Irish DPC, a little bit from Europe. Notable cases, just very briefly glance on just to show that large fines are being hit, and smaller fines for cookie violations. And then I'll have a chat about Cookiescan, which is our product at the end, and why we ended up developing a cookie management platform, and the reasons around that. So that's what we'll cover.
Just before you start there, Paul, before you get into the technical detail, it's a question you might not be able to answer. Why are they called cookies? You might cover that anyway.
I've got no idea.
All right.
I've never actually looked that one up. We all know what cookies are. They're small digital files that go on a computer and gather data and send it to the owner of the cookie. I don't know why they're called cookies. I know why pixels are called pixels, because it takes a pixel on your screen.
Yeah.
But no.
All right. Okay. Well, there's a prize for anybody that can enlighten us during the course of this.
And we'll have that as part of the conversation. So somebody else can answer that one.
Oh, we've got a reply already.
Oh, go on.
So it says the term cookie for internet cookies comes from programming term magic cookie. Magic cookie is a packet of data that a program sends and receives without changing it. And that's from Martin. Thanks very much, Martin. We'll get you some sort of prize.
Now we know what a cookie is. That's why it's called a cookie. That's brilliant. Cookies they're essential parts of most websites. And I've dragged out some statistics from various sources on the internet, but most of them were covering 100,000 websites. So as we say, 42%, I think, DPAS advertised of websites cover cookies. 55% of websites don't even offer users an option to reject a cookie. So it's still quite a moving area. So they serve functions for personalization, analytics, and advertising. So mostly around marketing or the performance of a website. Their use has to align with the privacy laws or data protection laws. PECR being the UK's variation. PECR came from the ePrivacy Directive that was set up in the EU to cover tracking technologies. And where they blend into GDPR is around the consent definition. So ePrivacy adopted the definition of consent from GDPR. And then obviously PECR rolled in with that. And then obviously GDPR for lawful processing and transparency and the like. So we've covered PECRs. So if you look at the ICO website and you look at any of the investigations they've had under PECR, most of it will be to do with email marketing campaigns. The ICO hasn't heavily got involved with cookies or pixels. They've put out a lot of start warnings around. They've looked at 100 websites to see where their compliance lay. They're now looking at 1,000 websites. And the same would go for Nobio, which is we'd all know them from Shrims, but they put in thousands of complaints to supervisory authorities in relation to violations of ePrivacy directives. So they're the frameworks, the two main frameworks. And then as I've explained, GDPR they complement each other from a data protection, data privacy perspective. The ICO gave guidance some years ago in relation to cookies, and the guidance together with the Irish Data Protection Commission and Europe has developed over time. Nobio has really assisted in that with the complaints they've put in and the findings of the violations in relation to freely given consent and how you can gather that. So the basic requirements that the ICO put out, which a number of websites don't even adhere to at the moment, quite a large percentage of. As I said, 55% of websites from one particular survey I looked up don't even offer an option to reject cookies. So it is that consent has to be obtained for any non-essential cookie. So cookies are normally split into categories. So we split cookies into 5 categories. We do essential, and that's essential for the functionality of the website. So if we use an e-commerce website, the functionality would be your shopping basket. So any cookies or pixels that are relevant to the collection of items that you've looked at and put in your shopping basket, they store that information. Sometimes until you decide to purchase them, and longer. And then you have cookies in relation to marketing, which is either contextual or personalized direct marketing. Statistical cookies, so Google Analytics, for example, would be statistical cookies. And that's all around how many pages you visited, how long you stayed on a page, what particular links. And then tags, pixel tags can link into that because they look at keystrokes, so search definitions. You've searched for a tent or something like that, they will store that information. Preference cookies are in relation to your preferences for a website language, font, accessibility. And then you have a vast number of unclassified cookies. Now, not all cookie management platforms will categorize unclassified cookies or expect you to give a consent for that. But what we found when we researched cookies is the number of unclassified cookies that are developed by software plugins or website companies that haven't got a defined purpose. Some of them will stay on your computer for years. They'll collect data of some description, but they haven't got a defined purpose, so you don't know what they do. So some cookie management platforms ignore unclassified cookies, or they will list them, but they won't drop them into a specific category. So you have to be careful on what you're consenting to. So that's consent. Has to be freely given. It can't be bundled, hence why we categorize cookies. The latest guidance is that you make your categories granular. So you would put cookies that are designed specifically for personalized or direct marketing. You would have those as a consent option or reject option. You'd have cookies that are designed just for contextual marketing, which is you've looked at a website for a particular product, it will send you adverts for that product. It isn't looking at keystrokes. It's sending adverts relevant to the website you viewed rather than your search or your interaction with that website. And they're asking now for consents for these particular items. We'll come on to that when we discuss consent or pay. And then you have to explain the purpose of each cookie. So in layman's terms, not in technical terms, in layman's terms, this cookie is designed to collect information in relation to the pages visited or the search terms that you may have used, but it has to be specific in relation to the purpose. Then it has to explain the expiry date, so how long the cookie lasts. So there's 2 types of cookie. You have session cookies, which last for the length of time that you're on the computer, or you have preference cookies, or sorry, session cookies and persistent cookies. So persistent cookies will have an expiry date, and we've seen some cookies with 9,000 days as an expiry date. I mean, ridiculous length of times that they would stay on your device. And bear in mind, cookies and your consent is in relation to the device that you're visiting the website on, because it tags your IP address, which is device purpose. So that's the ICO's guidance, is consent for non-essential cookies, clear purpose explained for each cookie, who the provider of that cookie is, how long that cookie lasts for. And then you go on to the Irish DPC, who also mirror the ICO, but they also talk in more detail about transparency around cookie notices. We are all fully aware of the requirements for a privacy notice under GDPR. There is no legal requirement to put a privacy notice on a website, that just happens to be the best window to provide that right to be informed. But there is a legal requirement to put a cookie notice if you use cookies, and that's under PECR, or the guidance that's been given out by the regulators. So a cookie notice has to explain what cookies are in layman's terms. So explain session cookies, explain persistent cookies, explain third-party cookies or first-party cookies. It also has to explain exactly what cookies that website is using. Now, what we found with Cookiescan is cookies are fairly fluid. If you put a new plugin, you change the font or color or theme of a website of any description, you can alter the cookies that website will use. So cookies can change month from month. So a cookie notice that's been put on a website in May 2018 or whenever, and has been left there and hasn't been reviewed on a regular basis, is going to be non-compliant because it may not explain exactly what cookies are being used. You can't do a catch-all and list 50 cookies just in case they're being used. You have to describe the cookies that are being used. And you have to review those practices. It's also a review of consent mechanisms. So with Cookiescan, we decided on how we re-consent. So every 6 months, our cookie that's placed on people's devices to remember what their preference setting was around cookies expires. And then the banner will pop up again on that device every time they visit somewhere. So again, we'll add in cookie notices. A little bit of a bugbear of mine is they are notices. They're not policies. Policies are internal documents. Notices are external. So that's the basic requirements around cookie compliance. For the banner, 2 years ago, again following complaints in Europe, it was decided that the accept all button was always on the first layer, and the reject all button or deny was 2 or 3 clicks down, sometimes even further if you went on to Amazon Web Services. And it was quite difficult to find a way of rejecting all cookies at the same time. Easy to accept them all, difficult to reject them all. So the ICO and European supervisory authorities have come out now with the guidance, and it is an expected part of compliance that the reject all and accept all are all on the front layer of a banner. So no pre-ticked boxes, which goes obvious for saying, and your reject all and accept all must be on the first layer of the banner. And that is the reason why pay or consent came about, is because the ICO made it too easy for people to reject all, and it sent marketing teams into a bit of a frenzy with certain websites because they lost the ability to track users. And it says here the impact on marketeers from a Google statistics is 41% of marketeers worried about losing their ability to track users' behavior with third-party cookies because it became too easy. So that's when the consent or pay arrived.
So just so I've understood that, then the ICO actually listened to consent of marketers as well as people that are using websites.
Well, the ICO did. Strangely, there is a difference of opinion. The European Data Protection Board opinion in 2024, the 18, I think the number is. I'll put a link on. Put that consent or pay would never comply with GDPR's definition of consent being freely given.
Right.
And it would be very difficult. Whereas the ICO's guidance has come out to say that the data protection law is not there as a barrier. It can comply with certain circumstances, and we'll explain them shortly.
Okay.
It's a debate in itself, because freely given consent, you're never to make consent part of a condition. It wasn't conditional consent, and that's what consent or pay seems to be. But the large newspaper organizations brought it out
To set up your device using a screen reader,
before
operator by pressing Windows and Control and Enter.
the ICO.
For more accessibility features,
Excuse me.
press Windows and Q, or select the accessibility
1 second.
icon.
Technology. Just while Paul's just
We'll have to do a webinar on being listened to by
yes. Those devices, I'm not going to say the name of mine here.
No,
Get it going, but
we all know
they can
what
be,
they are.
yeah, they can be rid of them. Just while Paul's regrouping there. Any questions so far? Please put them in the chat box if you've got any questions at all.
So it's an interesting world when it comes down to cookie compliance, because, as I said, websites, it's a requirement. So if you're looking at the generational differences for cookies before we go on to non-compliance, again, younger tech-savvy generations like millennials or Gen Zs are more willing to share their data for personal benefit. So if they see that they're going to get personalized benefits from using a website, so personalized advertising or marketing, they're more likely to share their data. Secondary study emphasizes the disparity, showing 95% of millennials or Gen Zs just willingly share their data. It isn't a concern for those, whereas 55% of over 55s are a little bit more conservative in relation to that. So examples of non-compliance, and please look these up and do Google searches around it, because they are varying. So £100 million fine for Google in 2020 by the French regulator for setting cookies without users' consent or failing to make a straightforward way to reject them. And this is where the first layer of rejection started to come about. British Airways faced scrutiny by the ICO for failing to implement appropriate consent mechanisms for cookies, risking heavy fines. The ICO hasn't fined particularly for cookie violations. They've added that into a summing up in some way. And an Irish retailer fined €25,000 for relying on pre-ticked boxes. How many of us have gone on this day and age to a website and the cookie is pre-ticked? It is more common than one would think. So, I mean, look up on the ICO or the GDPR tracker and just put in for ePrivacy violations. Spain are fairly hot on it. There was a recent case that just came out at the end of last year, beginning of this year, for an appeal for somebody put a complaint in 2021, and with the assistance of Novio, the complaint initially went into the Austrian Data Protection Authority. The data controller was in Spain, so they sent it to Spain to deal with, and Spain dealt with it in 2023 under the new legislation or new rules around ePrivacy, and said there was no complaint, there was no offences. What they failed to do is they failed to look at the state of the website in 2021 when the person actually had the issues. And then it highlighted the fact that there isn't a one-stop shop for ePrivacy or PECR violations, whereas there's a one-stop shop for GDPR violations. So there is still some work to be done in relation to cookies and trackers.
Paul, just before you move on to the next slide, we've got a couple of questions. Are we going to touch on DUA later on? I'm not sure what
DUA.
Might have to get a clarification about that. And then somebody else has sort of said, it seems the ICO has not really fined for cookie non-compliance as yet. What's your sort of take on that, really?
Acronyms, I'm not brilliant at remembering acronyms, so DUA, when it's explained, we'll try answer that one. The ICO, my take on the ICO's fining in general is they lack that side of enforcement in totality, not just around cookies. but when Elizabeth Denham was the commissioner, PECR violations were prevalent, but mainly around the telecommunication preference or the failure to check that, and email marketing or SMS marketing. Very little around cookies. They bring out a lot of guidance on cookies. 2023, they looked at the top 100 websites. 52 or so were found to be non-compliant, and they were given a time to bring themselves up to compliance, but we haven't heard any more about that. What's happened? At least I haven't found anything. That's somebody might have found a document that's relevant to that. They're now looking at the top 1,000 websites now with the guidance that's just come out on consent and pay. But they don't seem to be taking a very heavy stance of enforcement. And that's why we have statistics like 55% of websites just don't offer the preference. Where I'm from, Jersey, there's no requirement to collect consent. So we never adopted any PECR or ePrivacy requirements because Jersey sits outside the EEA. We're a third country. Crown dependency, but our cookie requirements is all based on legitimate interest. So it's an assumed or implied consent sort of basis. Whereas Guernsey, they adopted the article in PECR for cookies, and they require consent. So the difference even between our two islands is and the approach is quite dramatic.
And again, just another quick question, and then we'll let you move on. You've covered the need for obtain consent. However, how many websites now rely on legitimate interest as a legal basis for using cookies? Is this something you're going to cover today?
Yeah, well, we'll do it now. So the requirement of PECR is to collect consent. Those consent records and whatever cookie management platform you use ensure that they keep your consent records and they match it back to the IP, and they have the consent for each category. So if a cookie management platform only puts it down into 4 categories or 5 categories like we do, ensure they have the consent preference for each IP address for those, because we've had clients who've received letters demanding a financial compensation for dropping a cookie without consent, or they will go to the Information Commissioner or the ICO and make a complaint. And when we've said to the people, so right, give us your IP address, and they've given it, we've clearly proven that what they've done is they've gone on the website, they've consented, and then they've immediately brought the banner back up again and removed consent. Well, the moment you consent with a cookie management platform, it will allow the cookies to go onto a person's device. When you remove that consent, it then blocks those cookies, but there is a record of that cookie on the person's device because of that speed of consent and non-consent. So they've tried it that way. If your cookie management platform hasn't kept your records of consent, which is a requirement in GDPR around consent, you could be stuck. And just make sure that you're happy with the length of time that they are storing those. We reconsent every 6 months, so we keep a record of consent for 12 months, and then we just roll it around in that way. But that's something to ensure. Legitimate interest is legitimate interest is the basis that you would use for essential cookies. If you want to go down that road, we've had clients who want to use legitimate interest for statistical cookies. And we've done legitimate interest assessments, which would be a requirement to ensure that that is appropriate, and DPIAs to mitigate any risks. And the mitigation they've used is as soon as they collect the data, it's immediately anonymized. So they don't link anything back to an IP address. It's all data that's collected for their use. And don't forget, Google have something called Google Consent Mode, which we have built into our platform. So when people say no to statistical cookies, Google will still collect aggregated data for you and send it to you as a statistical measure for your website. So there are ways to look at your banner, look at how you're utilizing cookies on there and what you're utilizing them for. If you have a website where you have YouTube clips running in the website as part of the functionality, you can justify putting the YouTube cookies that are collected into an essential category. Just ensure that you've done your DPIAs, and if you're using legitimate interest, your legitimate interest assessments around that, so you can show justification for that. The ICO may disagree if there's a complaint gone in, but you've shown accountability by carrying out your proper assessment. Sorry, Andy, I hope that answers.
That's fine. That's great. Yeah. We've got more questions, but we'll move on to some more slides and then come back to those if that's okay.
Okay. So best practice for cookie compliance is ensure you hit the minimum requirements, no pre-tick boxes. You are given a clear method for somebody to consent or reject your cookies based on a granular approach. Rejection or change of preference must be as easy as it was to give. You will notice a lot of cookie management platforms put a little icon down in the left or right hand corner of a website, and that icon remains there as you travel through the website, horizontally or vertically, whatever way you want to do it, and you can immediately bring up the banner again. Clear purpose for each cookie, and make sure that it's in plain language, you could understand it. Clear expiration dates or expiry dates for the cookies, so how long they last. If they're session cookies, make it clear what a session cookie is, and make sure that your cookie notice is relevant to exactly what cookies are going on. Now, if you have a static cookie notice on your website and it's not directly linked to your cookie management platform, there's a good possibility it's going to be non-compliant, because depending on how long it is. Cookiescan, every time it scans your website, it automatically generates an updated cookie notice for you. So it's just ways that you can automate these processes, so you take that worry away. Design your cookie banner is crucial. So no dark patterns. Dark patterns is a phrase that is used quite a lot around this area. So what that means is you're not nudging people towards an accept. So you're not making the accept button really bright and obvious and the reject button virtually the same color as the background of the website. You'd need a magnifying glass to find it. You have to make them equal. You have to be careful on your colors and your theme you use on your banner. There's nothing wrong with having your banner matching the theme of your website, as long as it's clear what the buttons are and they are presented in an equal fashion. So you're not making your accept all more prominent than your reject all. And it's obvious to somebody looking at it that they've rejected or they've accepted. So we use sliders, and then we use a green slider or a red slider or variations of those two colors to ensure that people are fully aware what's on and off as far as consent on a cookie. And then regular reviews around your cookie practices. So as I said, make sure your cookie notice is relevant to your website. And that can change. You need to ensure that every time you make any change to your website, add a plugin, take a plugin away, or there's updates to any YouTube or LinkedIn or Facebook links or pixels on your website, you change your cookie notice. Doing it manually can be quite a labor-intensive process sometimes. And involve, as data protection professionals, data protection officers or managers, whatever you might be involved in the cookie process of the websites. Do not leave it to the marketing department. And I'm not being derogatory towards marketing people, purely professional. They do a fantastic job, but their approach to cookies is going to be slightly different than a data protection or data privacy professional's approach and thoughts to cookies. Some cookie platforms will allow non-compliance, so be careful on the one you choose. Some will allow you to select pre-tick boxes as soon as they pop up. Some will allow you to use dark patterns, and some will allow you to override people's consent mechanisms and just drop cookies as and when they want to. My experience is the less onerous a cookie banner is, and the more data that cookie collects is the advantage for a marketing department. The more that we as data protection professionals stick to the compliance and regulation, we can lock heads a little bit. But as I said, there are ways around it. You can use the law. The data protection law was never put there, or PECR or ePrivacy, as a blocker to economy and business. There are ways to do it. So that's what I would say from a best practice perspective. Is there anything you want on that, Andy?
No, that's fine. We've got more questions coming through. I'm just going to fire a quick one at you just now. Is having a cookie inventory a regulatory requirement?
So if they're talking about a ROPA, if you're required under GDPR to have a record of processing activity, yes, cookies is a processing activity. We always list the categories of cookies on a ROPA, the legal basis. So obviously consent being the majority one, or legitimate interest around that. And yeah, there is a requirement to have them on a ROPA or an inventory. To have one standalone, no, there's nothing under PECR that I've read anyway, or ePrivacy, that would require you to have a separate inventory. I'm blending that into the requirements around GDPR or whatever data protection legislation that you have to comply with. If there's a requirement for a ROPA, clearly cookies are a data processing activity, and they need to be listed on there.
Great.
Okay. Consent or pay. So the ICO released guidance recently on consent on pay. It's quite extensive guidance. It takes you through 5 pages on their website on the various models. This all came about because, as I said, large publishing companies, the Telegraph, the Daily Mirror, Express, when the requirement to have the reject all button came on the first layer, they started to look at different ways of utilizing cookies, particularly marketing cookies, around there. And so they started to use a consent or pay model. The ICO started a consultation early 2024. The end of 2024, the European Data Protection Board came out with its thoughts and guidance around consent and pay. On the day that the European Data Protection Board brought out its guidance, the ICO shut down its consultation, and then they've come out with their own guidance, which is in slightly contradicts the EDPB guidance. So the similarities between both. So let's just run through what I've got on my thing. So they've said, the ICO have said, consent has to be freely given. Users must have a genuine choice to consent without unfair penalties or for refusal. So they have to have the same access to the website as somebody who consents. There can't be, they haven't put a condition in there, which is a bit confusing, because you either consent to, and what we're talking about here, we're not talking about all cookies, we're talking about marketing cookies that are personalized to you. So whatever you look at. Transparency has to be clear, plain language, explanations of consent options and implications. Alternatives offer non-personalized options, such as contextual advertising or an appropriate pay option. So contextual advertising is, as I said, it's advertising based on the content of the website, not on your interaction with that website. So if you click an advert on a website, that's where personalized advertising would come in if you accepted that cookie. And then privacy by design. avoid misleading designs, dark patterns, user-friendly mechanisms for granting or rejecting consent or paying, and easy to withdraw as it is to give. I mean, that's fairly basic stuff that I pulled out of quite extensive guidance. But what it says, so the European Data Protection Board announced its new release, so Opinion 8, 2024 regarding consent and pay. So both the EDPB and the ICO agree that consent and pay models must ensure that consent to process personal data for personalized advertising is freely given, fully informed, and can be withdrawn. So they're both on a par with that one. They both highlight the need for an equivalent alternative to pay or consent and pay, such as alternatives should require that users to consent to the processing of personal data for behavioral advertising. So that's the contextual advertising. So the differences between the European Data Protection Board and the ICO on consent and pay is the European Data Protection Board is more explicit in stating that in most cases, consent and pay models will not be able to comply with the requirements for valid consent under GDPR. So the ICO, on the other hand, states that data protection law does not prohibit consent or pay models in principles, but organizations must ensure that consent is freely given, fully informed, and can be withdrawn without detriment. The ICO goes on to provide more detailed guidance on what organizations should consider when setting consent and pay models. Sorry, I'm reading from here, so you have to forgive me. Such as appropriateness to the fee. So the fee has to be appropriate to the service that's been given. What they're not saying that you cannot charge for a service on your website. So if we keep publishing companies in mind, they charge for you to read their newspaper. You can't just go on their website and read their newspaper for free. You've got to buy a subscription to read that newspaper. What the consent and pay is all about is the personalized marketing element of the cookies that they have on their websites. So if you consent to the personalized marketing, you will get all these adverts based on what you've looked at or what you've clicked on or search term you may have used. If you pay, you don't get any of that. You get contextual marketing if you consent to that. Or if you refuse for everything, you get nothing. The ICO is seeking views on consent and pay models and plans to update its guidance on cookies and similar technologies, while the EDPB is developing guidance on consent and pay models with a broader scope and plans to engage stakeholders on this upcoming guidance. So they're both a little bit of loggerheads with it. So it's watch this space. But what I don't want you to take away from here is that you can suddenly start making your cookies into a financial gain for yourselves, start making money out of people refusing to have cookies. It's predominantly for larger organizations that are providing a service. So the publishing companies is perfect example for that. The adaptation for it, so update consent mechanisms. If you want to bring in a pay option, and we're looking at bringing in a pay option as a banner choice for Cookiescan, you have to do your DPIAs around it. You've got to ensure that you are not overriding the rights and freedoms of the data subjects by only offering pay or consent options. They still have to have the ability to say no and leave it at that, and change their preference when it comes to that. But it's a bit of an open space at the moment with the guidance being so fresh. I'm sure you'll start reading an awful lot of articles on what to do and what not to do when it comes to that. But it's the ICO opening the door to changing technologies. And I think they're starting to stray a little bit from the GDPR definition of consent to something slightly different, which I hope doesn't start putting too broad a gap between that, because it's interfering. I believe it's interfering with people's fundamental rights for privacy. And some people just won't be able to afford it. I looked at the prices this morning. Telegraph is £16.99 a month for a subscription. It's an extra £1.99 if you want to pay not to get personalised adverts. Not everybody's going to be able to afford that, but they want to be able to utilise the services. So it's something to look at. Any questions on that, Andy? Or?
No, we have had a question here. What do you see in the future for cookie consent banners, and will it eventually be controlled in the user's browser settings?
You can control, at the moment, you can control to a degree your cookie, just block them. You can block all third-party cookies. Google have been talking for years about getting rid of third-party cookies. They were meant to have got rid of third-party cookies in total by the end of 2024. Like Firefox or Apple's Safari, they block third-party cookies. But then Google were starting then to look at different ways. When you look at the economics around marketing, cookies are a vital element to that sort of the e-commerce version of websites and how websites perform. And people need feedback on what people think. And that's what cookies generally do. You take aside the direct marketing aspect and the annoyance of that, you can refuse that on most, not all, on 46% of websites you can refuse it. But they are an important element for that sort of feedback. So if you get rid of third-party cookies, you're left with first-party cookies. You still, under PECRs and ePrivacy, need to have a cookie banner explaining to people what those cookies are. If you get rid of cookies altogether, we move into doing something like Google started putting segregations of people who are interested in certain elements. They will go in one bucket and they will get marketing for that particular item, and it will just change the landscape of it. I think cookie banners are an annoyance for people if they keep popping up, or if they accept it on the home page and then they go to a service page and a banner pops up. It's just very poorly put on the website. I think banners, we're looking at banners now for consent for multiple websites. So you just get one banner up and you tick the websites you want to consent or reject cookies on, and then you don't see that banner for another 6 months. So we're looking at different ways of providing this service. But if you don't have a cookie banner and it was just a free-for-all, your data would just go everywhere. And your data is valuable to these organizations. You're giving it away for free, they're making money out of it. If we have cookie banners, you have an element of control. You have a choice. I think a statistic here, people take 13 seconds to read a cookie banner on average. They just look at it and go, yes, no, end of. They don't actually read the content of it. Some of the cookie banners I've seen, they are so complicated. Amazon's cookie banner, hugely complicated. You've got to tick no or yes for each item. Some of them are already pre-ticked because they've decided that they're using a legitimate interest. So they've pre-ticked that as a yes, and you've gone, no, I don't want you using that. So you have to take your time reading it. And it's just one of those things. In the future, I think cookies are going to be around for a while because they are a method for organizations to get that feedback. They'll have a different name, they'll have a different approach. Cookie pixels map everything you do and immediately send that to a cookie. And then the cookie transfers that to a server. So that they'll find different ways around it. But I think the idea of a banner is not there to annoy, it's there to give you free choice.
Yeah.
And that's what people have to have, is free choice. So hopefully that answers that.
That's great. Yeah, we're just into the final 9 or 10 minutes here, Paul. So
Right. So
That's
where's my slide in relation to? So I was going to talk to you about Cookiescan. It was already. So I looked at when I started looking at website compliance. And one of the other things you need to do is an audit of your website, so you fully understand what you're using cookies for. But I started looking at cookie management platforms that are out there, and I found that they were either very technical to properly adapt to your website needs, and they didn't do what we wanted them to do. They gave free rein for compliance and non-compliance. And as I said, nothing derogatory about marketing, it's their job, but the majority would like pre-ticked boxes of everything, so they get all the data. And then there was nothing that was easily affordable for SMEs and charities. Some website banners cost £1,000 a year, some even more than that to implement. So I got together with a friend of mine who's a coder, and we developed Cookiescan. And it's a cookie management platform that will globally manage your websites, because we've mapped the cookie requirements from Europe, United States, and we regularly update that. We have what's called geolocation markers on it. So Cookiescan will automatically recognize where your website is being viewed and apply an appropriate banner. So if a website's being viewed in Jersey, there's no consent requirement. We just put a simple banner up saying we are using cookies. You can change a preference if you wish, but we have dropped cookies as default. Whereas Guernsey, 20 minutes away on a plane, it will display the exact same website, will display proper consent model on it. We then looked at when Austria, if any of you remember, decided that they no longer liked Google Analytics. So they banned the use of Google Analytics cookies within their country. No website in Austria is allowed to have Google Analytics as a directive. So we have geo cookie blockers. So we just put Austria in our banner, and you could have your website going over Europe. As soon as your website is looked at within Austria, you will not have Google Analytics cookies. So it's protecting you even at that level. I then looked at the blend of data protection rights, so right of access, erasure, and we have a direct link on the banner for people to be able to enforce their rights and make contact directly with the data protection leads, officers, whatever, within an organization through the banner. So it started to look at that. I think we're the first to do that. And as I said, automatically generated cookie notices, which has the link on the banner. So every time your website is scanned, it will update those cookies. So you can be safe in the thoughts that you are complying with that legislation. And we will not allow pre-tick boxes. End of story. Don't care what you want to pay. We won't allow you to put pre-tick boxes. So you cannot worry about that side of it. And then we looked at cost, what people are paying. Our banner starts at £60 a month or £60 a year for a standard. If you want to use Google Tag Manager, the likes of those as an integration to inject your consent events, I think our most is £190 for a premium account. So we made it affordable. We don't want to be greedy. Charities have a vastly discounted rate because the compliance need is there. We can't turn around as data protection professionals and say we're advocating compliance, but only to people who can afford it. It doesn't work that way. So that's why I developed Cookiescan. Quite ethical, I think, but hey, some people might not think that because it's cookies and it's an annoying little banner that pops up on the bottom of your website. But that's it. I mean, in conclusion, cookie compliance is vital. It is a legal requirement to have a compliant banner. It's not difficult. It's not rocket science. Don't get overwhelmed by technicalities. Keep it simple. Keep plain language. Collect consent when it's required. Make sure you keep those consent records for a minimum of 12 months. Some might want to keep them even longer. And ensure you know what cookies are on your website and how you're utilizing them. And that's really all I have to say about it. It was just a quick reminder. As I said, it's not a law course. It's not legal advice. It's a quick reminder of the basic requirements around cookie compliance.
Yeah. Well, thank you very much for that, Paul. That was really interesting. I'm just really conscious we've got actually a fair few questions
Right.
that weren't answered. I think we're out of time now.
Oh,
But
that's good.
I think what we'll make sure we do is we'll share those with you, and you can respond to those in more detail. Some of them were quite detailed. There's a couple that I'd love to have asked just now, but we are out of time. So thanks very much for that, Paul. Was very
Thank you.
interested. I'll try and make a bit more effort when I'm making choices about my preferences. I don't even take 13 seconds to read a notice editor.
I now know why they're called cookies. It's like I was at a cyber security conference in Manchester last year, and everybody kept on talking about the kernel. And I thought it was somebody that was doing a talk or something. I didn't understand what hooking the kernel was. You learn something new every day. Every day is a school.
You do. So thanks very much for your time, everybody, for your input and for your attendance. We'll send you some follow-up information. And yeah, thank you again, Paul. Thanks for your time.
Thank you. Thanks for your time. Bye-bye.